Good afternoon, everyone. Allison Scoburg here, Consolidated Planning Group. We're so happy that you have joined us today. We've got a new topic. You probably have heard us say this before about not leaving money to your loved one with special needs, but to add on to that, even a minor child. So we're going to be taking a deep dive in to that today. We are here with the Handley Law Office, Boyd Handley, attorney Boyd Handley. He's going to be talking through that with us today. If you wrote in a question, we've got it. We'll answer those questions during the time that we have together today. We're going for an hour, so if you're planning your lunch or what have you. We are in webinar mode today, which means that we can't see you or hear you, but we know you're there. We're glad that you're here and that you've joined us. Our chat box is open today for questions. We invite you to put your questions in the chat box, kind of same as usual if you've attended our webinars in the past. And so we're also here with our sponsors today, Hope for Three. And I'd just like to turn that over to Alondra for a moment to tell us a little bit more about Hope for Three, their mission, what they're doing, and any upcoming events that they've got coming up. So, Alondra, thanks so much for being here.
Thank you, Allison. Good afternoon, everyone. My name is Alondra, and I'm the Volunteer Programs Manager here at Hope for Three. We're so excited to have you all join us today. For those who might be new to us, Hope for Three is a nonprofit dedicated to honoring, supporting, and empowering families living with autism. We bridge the gap to vital resources, providing financial assistance for treatments and therapies, along with programs that support the whole family. For example, we have like our gal gathering, our teen huddle, where high school pairs up with an individual with autism and their sibling, and they have like fun events, and then they create meaningful friendships. And we have webinars just like this one's. Beyond that, we're deeply committed to community education and building a more inclusive, accepting world for individuals on the spectrum. Before we dive in, I wanted to extend a heartfelt thank you to Consolidated Planning Group and the Handley Law Office for partnering with us on today's webinars. We're so grateful for your expertise, your time, and your commitment to supporting our families in our community. But feel free to explore our website, hopefor3.org. And if you have any questions, I'll go ahead and leave our contact information in the chat. We do have some wonderful events coming up, our golf tournament and some caregiver timeouts and gal gatherings. Thank you so much, Allison.
You and I have attended those gatherings in the past, and they are great. It's just kind of dinner out one evening, and you're kind of just rubbing shoulders with other people that walk in the same path that you do, and they get it. And this a lot of good ideas come out of that group. And so, if you ever get a chance to go to the gal gathering for our moms or parents or caregivers out here, we've had grandparents at it as well. Definitely check that out. So. Thank you for all that you guys have been doing. You guys have been doing a great job for years and years. And so we are grateful to partner with you as well. So, having said that, I always just take about 1 minute just to share a little bit more about what we do and kind of some of the differences. So, um, Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is here to help you plan for the future of your loved one with a disability, as well as for your other family members, yourselves, your own retirement. Um, our when this is near and dear to my heart for people that are joining for the first time. I have four kids and three with disabilities. They're all adults. And I would say that when it comes to navigating these things, the things that we're not supposed to do, the things that we are supposed to do, we're always feeling nervous that we're going to make one wrong move, one wrong step, say one wrong thing, and it's going to mess everything up. And that's not exactly true, but there are some very important details that comes into planning for a loved one with special needs. So what I like to make clear is we're not the attorneys. Boyd, for instance, is the attorney. We don't set up legal documents. We don't do guardianship. We don't set up the special needs trust. We're the money. Who's going to care for my child when I'm gone? How much money do we need to fund a special needs trust? What public benefits are available? How and when should we apply? What do we do for that type of thing? How do I retire? stay retired, and still have enough money to fund that special needs trust. So that those are some of the things that we do. And so for the sake of time, everybody is going to get a copy of today's slides and a link to the recording. I always like to mention that in the beginning. So that way everybody knows that you don't have to write down everything that you hear today because you are going to get a copy of those slides. And having said that, I would like to turn it over to you, Boyd. Welcome back. Thank you for being here, and thank you for always advocating you, your wife, your daughter, your family. These people are a big deal, and they've got a bill passed, and they've done a lot of advocacy in the state of Texas, and they continue to do that. So I know we're going to hear about that throughout your presentation. But today we're going to be talking about why we shouldn't leave money directly to our child with special needs or to a minor. So having said that, here you go, Boyd. Thanks for being here.
Thanks, Allison. Just to let you know, we do a lot of things other than special needs planning and guardianships, but that's the part of my practice I love and I enjoy doing. This is my second career, so I'm not your typical attorney, so I think a little bit differently sometimes, which may be good or not. So next slide. Just to let you know, this information today is just general information. Every particular person's situation is different. So please take this in that aspect. Next slide. All right, what we're going to talk about today is the differences between a minor child and what they can and cannot inherit or do in the state of Texas until they turn 18, and then a disabled child, such as my daughter Caitlin. She's on SSI and Medicaid, and of course, she can only have $2,000 in assets. And there are situations where you may have a family member that gives your disabled child an inheritance by name. And we're going to go over the issues with that. The good thing, in most cases, we can fix everything in court, but it does get expensive. Next slide. All right, what you need to understand with minor kids in Texas, they can own property and have a title in their name, but they can't do anything with it without their parent signing it and selling it or whatever with it. So just be aware of that. And they cannot open up a bank account under the age of 18 without a parent or legal guardian. Um, all of these cases I'm going to be going over today are actually ones that I've actually done in my practice, and hopefully y'all will see after the day why you shouldn't do this with your, kids with special needs or minors. We had a situation about a year ago where a father died unexpectedly and left his 10-year-old son a $500,000 life insurance policy. Um, Now, that's, you may say, well, that's no problem. We'll just deal with it. But what's going to happen is the life insurance company is going to call you up and give you three options. They're going to keep the money until your child turns 18, and you definitely don't want to give $500,000 to an 18-year-old. They can also put that into a UTMA account, an underage minor account, and at least the money stays there until age 21, and that's not a good idea either. And the only other thing you can do is have the remaining parent file for guardianship of this state of your 10-year-old son or daughter. Next slide. The
Boy,
issue,
can we just talk about this for a second because
sure.
this really is a big issue. And if you guys have attended webinars with me in the past, you've probably heard me talk about this many, many times about how we shouldn't name our minor children beneficiaries directly, and we should not name our special needs child as a named beneficiary directly instead of naming, their special needs trust. So one thing that you talked about, the UTMA accounts, they are problematic. We don't see as much of the UTMA or the UGMA accounts anymore, but they become age of majority and it's their asset at that time, which makes them well over the $2,000 and makes it next to impossible to qualify for Medicaid or SSI. So that is an issue. But one thing that people think, I want to just talk about this because it's a big deal. There's two things that people think when this happens. If somebody accidentally left money to our minor child or our child with disabilities, is we just won't accept it. And if they've been left the money, that just not accepting it doesn't hold water when it comes to these qualifications. If they find out about it, then it is considered that their asset. So that's one thing I want to mention. And then the other thing is sometimes families think, I'm just going to disinherit that child. We're just going to leave that child nothing. We're going to leave that child's portion to a different child or somebody else that might care for that child. And Boyd, why don't you tell us about why that might not be a good idea?
Yeah, I had a client about a year ago that left all his assets to his son, and his son was in a fatal car accident where it was his fault. So the other family has sued him for everything. So what we had to do in his will was to change the beneficiaries to their uh, to his grandkids. And that I have a lot of clients that ask me, well, let me give the money to our typical child that will look after his brother and sister who has special needs. And that example is a great example. You don't know what's going to happen in your older child or your typical child if you give them money to look after their siblings. So definitely not a good idea. We look at trust within your will. It's called a testamentary trust. We do contingent trust that really stays dormant until you and your wife or spouse or significant other passes away. And then the minor's inheritance can go to that contingent trust. And then within that trust, we have like birth to age 18, you pay for normal things, 18 to 25, college, car, get half at 25 and then half at 30. So that's one way to take care of your typical kids. And then in my situation, I have a third party special needs trust. It's not funded yet. It will be funded at mine and my wife's death, but everything that we've got will go to our daughter third party trust. We'll go over the differences between the trusts in a minute or two. But you know, the main thing is definitely in your will have something, especially if you have kids under the age of 18. And then, of course, I have on my retirement funds, my life insurance, checking and savings. It goes to my wife first, and then it goes to my daughter's third party trust as a successor one.
Oh,
Uh,
so Boyd, what a lot of people do on beneficiaries, and if you're listening today and you're hearing this, you're not alone and don't beat yourself up. There's a fix for it. But what a lot of people do is if they're married, they name their spouse as the primary beneficiary, and then they say, well, if I die and my spouse is dead and gone, then we're going to divide the money equally amongst our children. And that is a very common thing, but that's where it is different when if you have a minor or if you have a child with a disability. And then the other thing that I just wanted to make clear is when we talk about this like, well, I'll just leave the money to his brother and his brother will pay for his care. It is not at all because we think that your other child is rotten and they wouldn't take care of their brother. That's not what we're thinking. But what we do know is people get divorced, people get sued, people die prematurely, life happens in that other sibling's life. And those are the things that when we do that, it could end up that your loved one with a disability ends up with no money. And that is why we don't recommend it. We don't ever want the money that's earmarked for your loved one with a disability to get tied up in a divorce or a lawsuit or some of these other things. And so that way, that clear delineation that Boyd's going to talk about is going to prevent that.
yeah. You know, as we mentioned with that $500,000 to that minor kid, the parent decided to go and get guardianship of the state of her son, which is absolutely crazy to have to do that. And then the mom had to put up a cash bond for a percentage of the 500,000. And then what we ended up doing was this is a typical kid. And what we end up doing is having, since it was over 150,000, the court ordered the bank to be the trustee. So we transferred the money uh, from the life insurance company to the bank, and they were the trustee. Unfortunately, the mother had to pay the bond prior to transferring the funds over, so she was out quite a bit of money for that. And now that the trust, the bank is a trustee, we're in the process of closing out her guardianship of the estate and then clearing her bond out. But it was just a lot of different steps in court in order to fix that issue where dad left money to the minor kid instead of a trust. So just wanted to go through some of the steps and let everyone know that it can be fixed, but it's a lot of work within the court system. Next slide. We had another situation. Again, as everyone knows, if your kid's receiving SSI and Medicaid, they can only have $2,000 in assets. Uh, we had a situation where dad died during COVID, died without a will, and he left his estate to his three kids. And one of those three kids is a 40-year-old gentleman who was on SSI and Medicaid. So we had to go into the family called me up and ask if we can do a special needs trust. So what, next slide. So what we ended up doing was doing what we called a 1301 management trust in the court system. And those management trusts can be a normal trust like I did with the typical kid that had the 500K, or it can be a special needs trust. Unfortunately, it's a first party special needs trust. And of course, that money has a Medicaid payback, and we'll go over that. But we were able to, fix it within the probate court system where the young man would not inherit any money and lose his government benefits. We actually took some of that money and put it in an ABLE account, which you can put $20,000 a year in. So, we can fix things, but again, it's a lot of trouble where if we just did some estate planning ahead of time, it would fix that. Next slide. All right, what is proper estate planning? Well, we talked about if you've got minor kids, definitely have a contingent testamentary trust in your will, or you can have a family trust also that does that. One of the good things about having a trust or a family trust, you can name how and when your kids will get their inheritance. And even in the contingent trust, we can say if the individual uh, is getting means dependent government benefits, then that will go into a special needs trust. And I'll do a contingent special needs trust or a contingent regular trust with wording for special needs trust. Again, as with my daughter, our beneficiaries are life insurance, retirement funds is her third party trust with that. So that, those are what you can set up now. It takes a little bit of money now to set all of those up, where if you go to court, you're going to be spending 3 to 4 times the amount of money that it takes to set up a special needs trust or a family trust with you. The one thing that if you're setting up special needs trust and you've got a retirement account going in there, be sure your attorney puts secure Act language in it, which has to deal with the required minimum distribution. Because most of the times that if a trust, if a retirement funds goes into a trust and you've got a disabled or special needs person, it's the normal 70+ year required minimum distribution. But anyone else, you're going to get between 5 and 10 year distribution. So it's always good to put that additional language into your special needs trust or your family trust. Next slide. You know, the other thing that you have to worry about with a UTMA account, and as Allison said, we're not seeing as many of those. Most of those were set up by grandparents. And if you're having to get guardianship of your loved one at age 18 and that particular individual has a UTMA account, then that's his or her assets, and you're going to have to go after guardianship of the person. So I normally tell my clients if they've got any bank accounts in the individual's name that's fixed and go through guardianship, that's spin that down or move those into a special needs trust. because what happens in most counties, uh, they won't allow you to have guardianship of the person with a account. Now, we did have some major law changes the first year where you can still get guardianship of the person if the individual has $20,000 in assets. I personally haven't done one of those cases yet, but it is in the law. So I'm waiting to see how that actually pans out with looking at some other cases. But what you
Want
don't
to
want to
mention
do, yeah,
these UTMA accounts and UGMA accounts too. Again, Boyd, I'm like, if somebody's listening today and they know that they have an UTMA or an UGMA account for their kid, like, what do you do? How do you fix it? What you do is you liquidate the account, and it is a taxable event. You liquidate the account, and you can turn right around and put that money into an ABLE account. You could put it into a 529C, and there might be people here sitting here thinking, well, my kid has a 529C. Is that going to mess it up? The college program under 529, and that isn't going to mess anything up because that isn't the child's asset. The parent or the grandparent is the owner. The beneficiary is the said individual, but that money goes directly to the school. So that's not going to mess anything up for SSI or Medicaid if it's a 529C. It's the UTMAs and the UGMAs that can be problematic. And we can help you with that if you've got questions. They're not that frequent. It's something law did a long time ago, 20 plus years ago, is typically what we've seen, or something that somebody started 20 plus years ago when their kids were really small. But there is a fix for it. Don't panic. We can help you with that.
yeah. And as far as guardianship goes, Montgomery County is the only county that will allow you to cash that out at age 21 and still get guardianship of the person. So it's really a big thing with parents going through guardianship. And what we don't want is that we have to get guardianship of the estate with an 18-year-old. Because what happens is that the parents will have to put up a bond based on the assets, and then that bond's renewable every year. So it's just something that is not very viable or very reasonable to do. Uh, I went ahead and put this in there. You know, there are alternatives to guardianship. We talked about the ABLE account. You've got the representative payee, which is your SSI account, and some others. And then, of course, down there, number 12, the 1301 Management Trust and Special Needs Trust. And there's something called the Texas Pool Trust. So, there's places to put your kids' money versus giving it to them outright. Next slide. We talked about the first party special needs trust in the court system. If your loved one with special needs does inherit something, this is the 1301 trust, special needs trust that we have to set up. The bad thing about this is that it has what we call Medicaid payback. So what that means is that once your loved one passes away, Medicaid can come back and get whatever money's left in here. So what we try to do is spend that money from the first party trust down with everything. Next slide. Third party trust, we've got a first party too. My daughter works a little bit, so we put her work money into her first party trust. But the third party trust is the big one where the parents can set it up, or the grandparents can set it up, and it's third party money going into it. So we've normally, what parents do with this is that they don't fund it until they pass away. In my situation, we've got a little bit of money that my parents gave my daughter prior to them passing. So, but our funds won't go into our special needs trust until they pass away. The problem with the special needs trust, the interest earned is taxed at the highest tax bracket. So that's why we normally just put these trusts in our safe in our closet until we actually need them with that.
Let's talk a little bit about people that are getting Social Security or SSI for their loved one with a disability, because I've had this come up a couple of times and recently again, where there's some confusion. They've got this The special needs trust set up, third party, first party. I've seen both happen, where then they link the SSI to be direct deposited to a third party special needs trust. You can't do that. It is a no-no, and you can't do it to the first party special needs trust. So I just want to mention that out loud to people. In theory, it might make sense that you could have it direct deposited to the first party special needs trust, but it doesn't really work that way. And so if you want to avoid a conundrum with the Social Security Administration, make sure that you're not setting it up for the direct deposit to go into the trust. I just want to mention that. It's kind of been an unraveling for some families that we've seen. It was just a mistake.
Yeah, it's also very confusing on your SSI application and ask you to put a bank account for the funds to go into. And technically, you can't open up a rep pay bank account until you have the letter from Social Security to open it up. So just be aware of that. Also, just let me mention that in a divorce situation where you're getting child support prior to age 18, it's the parents' income that's coming in. But once these kids turn 18, in the eyes of SSI and Medicaid, it's their income. So that's where you may have to, hopefully you had your family law attorney that did the divorce understands special needs and had it set up where it would go into a first party trust account once they start turning 18. But I've had a lot of people come to me and say that that was not done. And right now, well, in the past, I'm not sure how it goes now. The Attorney General's office would not deposit directly into a first party trust. I think you can probably get by with that by just giving them at age 18 a new deposit account where they can put it in there and not say what kind of account that is. But just be aware of that once these kids turn 18, that income's their income now.
With my understanding on that and the updates on that is that it isn't monitored. Like, you know how like there's child support enforcement, it doesn't go through that office. It's
Okay.
outside of that if the child support is going to the first party special needs trust. And my understanding, if it's not set up that way, then you do need a court order. Like they say you really can't just go in and change where the bank account is going to, that they need kind of words on that. And my advice, I'm always, suggesting that if this is you and you find yourself in a divorce situation, to Boyd's point, getting this right on the front end is a lot cheaper than trying to work it out on the back end, but it definitely can be worked out on the back end. A lot of families that have kids with disabilities get child support post age 18. Or indefinitely, and that's where you want to make sure that this goes to the first party special needs trust. So whether you're the receiver of child support or you're the payer of child support, we're not pro or against anybody, but what I am is for families working that out for the best interest of the child, which is to go to the first party special needs trust. Who it gets paid to doesn't really, matter if it's the same amount of money, but it going to that first party special needs trust it will essentially make the individual, be it that they have a disability that qualify for SSI and Medicaid and other Medicaid programs. So it is an important consideration.
Yeah, absolutely, absolutely. And a lot of time, there are a few family law attorneys in Texas that do special needs, divorces with special needs kids. But if your attorney does not have a lot of experience on that, a lot of times they will hire special needs attorneys as consultants to that. So definitely, if you're in the future, unfortunately having to get a divorce, be sure your family law attorney understands if you have a special needs child with that.
Let's talk about the finance of that too, because in these situations, a family often needs a family law attorney that's handling divorce matters, and then you need an estate planning attorney like Boyd that could handle like your divorce attorney doesn't set up a first party or a third party special needs trust. They don't do that. They're handling family law matters. So in these situations, I just like me people to be aware that they often have more than one attorney involved and will have the expenses involved with that. But I think it's important to get it right. It's important. We're happy to make referrals to family law attorneys that are nuanced with special needs. Divorce, we hope you don't find yourself in that situation. But really getting it right does matter. And there's not a whole lot of attorneys in family law that are specialists as it relates to individuals with disabilities.
Very good. Yeah, it's funny I bring that up. The reason I have that note in the front that this is uh, general information. One of my mentors was a consultant for a divorce case, and the client, her client came in and said, "Mr. Handley said do this, that, and the other." So my mentor came back and asked me, "What are you telling these people?" So just take all this for as general information because everything's different. But I got a kick out of that. So next slide. Oh yeah, able count. There we go. We've talked about this. Allison definitely can help y'all with this, but you can put up to $20,000 a year into it. Unlike a third party trust or you can't put property, you can put property and stuff in those, or there are some limitations with that. But unfortunately, with Able, you can only put cash in it. But it is a situation, a utensil, well, a deal that you can use for money for your special needs folks. Uh, Allison may have a different comment on this. I normally tell parents is if their kids are moving out into an apartment after age 18 and they need help in paying for that apartment or giving cash to their loved one and they're on SSI and Medicaid, the ABLE Act can help with that. You can pay for lodging and give cash to the beneficiary, which you can't with a special needs trust. So it has its uses with that. But that's normally with my clients what they use it for. Uh, Again, it is subject to Medicaid payback, so just be aware of that. I tell a lot of clients that with Able Act, if you're paying for, uh, apartment or something like that, just understand your monthly outcome from this account and put money into it accordingly. Now, if you're living in a group home at $2,500 a month or somewhere like Brookwood at $5,000 or $6,000 a month, then you'll never put enough money into an ABLE account to pay for that each month. And I've had we used to have a good friend, Allison knows who it is, that retired from SSI, and he basically told me that just put into a family trust and lose that 1/3 that you'll lose each month from your SSI payment and pay it out of a family trust. What happens, what I'm talking about with the 1/3, if you have a loved one on SSI and Medicaid and you don't have a rental agreement with them and you're giving them free room and board, then SSI is going to deduct approximately 1/3 of your monthly stipend that comes out to you. So it's basically, as Allison will definitely tell you, we're trying to understand the buckets where you put the money, who you put it to, and by understanding those different things, you can definitely come out more in a smooth process with your loved one.
The one thing I want to say, a couple of things. There was a change to the law this year with the ABLE accounts. It used to be that the disability had to start prior to age 26, and then this year it changed to the disability needed to start prior to age 46. The other thing that I want to mention about the ABLE is they complement the special needs trust beautifully. So people say, should I have an ABLE account or should I have a special needs trust? And I would say you should have both, right? Because an ABLE, to Boyd's point, can pay for things like shelter without a 1/3 reduction to SSI. But the kids are not always going to be on SSI. Later, when you retire, you turn on your Social Security or your Social Security disability, they're going to switch over. And those rules that you have for SSI and the rental agreement are not the same when you switch over. You don't have to do those things. But one thing I just want to caution everybody on is because people hear this all the time. If I heard when you switch over from SSI to childhood disability benefits or, beneficiary if it's under a parent's record, that $2,000 limit doesn't matter anymore. And that is simply not true. The only reason that $2,000 limit is not going to matter anymore is if you don't care about Medicaid or Medicaid waivers. If you care about Medicaid or a Medicaid waiver, we do webinars on Medicaid waivers, HCS, Texas Home Living class. There's a number of waivers. All states have waivers. I was just naming off some of the ones in Texas. But if you care about Medicaid waivers, then you care about Medicaid and you still got to follow those $2,000 guidelines. Okay. So that's really important to know. So also the last thing is Boyd mentioned earlier that those special needs trusts are not always taxed, they're not taxed favorably. You got to distribute the income. And if you don't distribute the income, they're taxed at 37%. An ABLE account grows tax free and there's tax free distributions. You put in after tax money, anybody can contribute to anybody else's ABLE. I could contribute to your kid's ABLE. Okay. Anybody can contribute. It's after tax money. The money grows tax free and it's tax free distribution. And it is penalty free distribution as long as the money is used for achieving a better life for an individual with a disability. So those are some other little factors that you might consider. We open ABLE accounts for people all day long. But the thing is, it's a minimum. Like he said, $20,000 a year is the max that you can put in. We never want the account to be over $100,000, okay, for SSI purposes. And the other thing, big thing, you can't make like, so let's say I had life insurance and I wanted to make my child's ABLE account the beneficiary. You can't do that. That is not, that it doesn't work that way. Okay. So just a few other things on that. Thank you, Boyd.
Oh yeah. We talked about grandparents 529 account. You can actually move that to an able account. Uh, again, we're not seeing I put grandparents down because you're not seeing a lot of these accounts set up by younger people. We talked about the parent dying unexpectedly and leaving life insurance to a minor child. Even worse with your child with special needs or disability. And when a parent dies without a will in Texas, then and you've got just say three children, each one of those children are going to receive one third or their equal share. So just be aware that if you've got a child with special needs in your family, please get a will and have it set up where they won't receive anything. And again, we can fix it in court, but it's a lot cheaper to plan ahead and understand, even with minor kids. I think that's what a lot of families don't think about is that having minor kids, there are limitations on what you can give them. I guess in my family, we think about special needs all the time, but I do have a lot of young clients that, have kids 3, 4 years old and, they don't have a will or anything like that. And you really need to understand what the minors can inherit. And what you don't want to do is have the court appoint a bank and then pay the bank each year their percentage of what your estate is going for. So.
We had a question that I want to read. I think I answered the other ones. It says, Boyd, is there any reason to leave assets in a family trust, for example, a living revocable trust that converts to an irrevocable trust upon the grantor's death versus transferring the assets to the special needs trust? And does that depend if they have more than one child or more than one heir?
Yeah, I do those quite often where we just have language in there where if once the parents pass away and it becomes irrevocable, uh, if any of that money is going to a special needs child or a young adult, then that would go through a special needs trust with that, and that way we don't actually have to set up a special needs trust. The trustee would do that later in life, and that's something where, as Allison said, down the road, if they're not getting SSI and Medicaid, then you can just keep that money into in that revocable trust. And then again, if they move out to a group home or to a residential facility, then that trust can pay for that. So by having that into a living trust, it's very flexible. I normally don't do those for younger couples. Just the point that, if you put your house in it and sell it, you're going to be taking houses in and out, which is fine. But probably do more of those trusts for older families that want to set up for their kids, where you keep everything out of probate, or they one of the spouses is in bad health, and so everything goes to the living trust when one spouse passes away, and then that money is looking to look after the remaining spouse. So.
So I think a couple of things that I'm thinking about is first things first is that a revocable living trust, a trust, just a straight up trust, not a special needs trust. They're not the same in the eyes of the Social Security Administration as what is considered an exempt asset. So when it comes to our loved ones with a disability, an exempt asset is the ABLE account and the first or the third party special needs trust. Those are the exempt assets. So keeping that in mind and asking yourself the questions, do we want Medicaid? Do we not want Medicaid? Do we want SSI? Do we not want SSI? Is going to be important if that person has more than $2,000 in their name. So I just want to remind that. And then the other thing, Boyd, you talked about the testamentary special needs trust, and this is something that lives inside a family's will. They have a will. They do not have a standalone trust set up right this instance, but there's wording in the will that creates that special needs trust upon the parent's death. So one thing I want to mention on that is a couple of things. Now, I have chosen to have standalone special needs trust for my kids. The reason I made that choice was because I want it already set up. I don't want it to take weeks or months. If your kids have needs right now and it takes weeks or months to set that up, then that's kind of a timeline that I think about. But the other thing that you've got to think about, and I think sometimes people forget about this, is if you have a testamentary special needs trust inside of your will, and you have aging parents, your loved one with a disability has aging grandparents that want to leave money to said child, that special needs trust is not established, and it's not going to establish at grandma and grandpa's death. It's only going to establish at your death. So if your loved one is possibly going to inherit something from grandparents or other family members other than the parents, you might need to have a standalone special needs trust set up ahead of time.
Yep, I agree fully with that.
Oh, I can't wait to hear this. This
Okay.
is what I'm talking about, our big deal. The Handleys are a big deal and all the advocacy that you guys have done. So share with everyone your HB 1188 and the Caitlin Handley Act.
Yeah, about 4 years ago, we started working with the ARC of Texas, and knowing that in the school systems, the parents were not required to know about the LITAs or the Medicaid waiver programs until age 14 when these kids were going into adult transition programs. What we went up and had a bill to do is that now the school systems are required to notify the parents of the LITAs and the Medicaid waiver programs at the first ARD meeting when the child is first diagnosed in school. The issue with all the Medicaid waivers in Texas is that about a 15 to 17-year waiting period. Uh, in our situation, we got through the House in the first 2 years, 4 years ago, and got stalled in the Senate. And we didn't know what we were doing, and we were letting the Arc of Texas run with it. This past legislative session, we started going up in January through May, about every week to 2 weeks, and talking with the representatives and senators and letting them know what the bill was about. We won't go into it, but we ended up getting it passed. And what was so great about it is that Caitlin, our daughter, she's 32, went up with us and met with the legislators. And what that did was that got the bill passed. It showed that our representatives and senators that these people with disabilities are regular people. They're not statistics. And we had one individual that was kind of rough on the edges and in a Zoom meeting we had. And then once that individual met Caitlin, they ended up being one of the sponsors of the bill. So Caitlin was able to win all of these people over by her kindness and her outgoingness, and they saw that a person with disabilities is a regular person and not a statistic. And of course, we've this is her testifying in front of the House Subcommittee on Education. She did it by herself. Of course, that's Emma, her well-loved bunny, and Emma's well known in the Capitol. And we were so proud of this young lady being an advocate for herself for the first time, and she did this in front of the Senate committee too. And we're just so pleased with her and how she's progressed in life. And I always like to give her her 2 cents with this. So, if you've got loved ones with disabilities, they will improve over life, hopefully. And Caitlin's got 4 part-time jobs, 6 days a week, and we're just so proud of this young lady by being an advocate for herself in front of these committees. So,
Well, we love the Hanleys and we certainly love Caitlin. She's often at some of the special needs resource fairs and helps out with that. She's just got a wonderful, sunny personality. She's great to be around. Also in the chat box, Harry Hanley said that the Hanley family has a bill drafted for the next legislative session that is for the expansion of this bill, and it would require public schools to tell families about the waiver programs and give them the information on how to get on these lists and things like that. And this is important. I can't tell you how many families we've worked with in the past that said they're on all the lists. And then they find out, no, they were only on the lists. They're 7 years into this, and they find out that they were never on the class list because it's a separate phone number, that they were never on the MDCP list because it was a separate phone number, and things like that. And there is confusion with that. At CPG, we do lots of webinars on the Medicaid waivers and educating you how to get on the list, how to check your status on the list, what the waivers are and what they're for. The waivers are designed to waive off some of the cost of care for caring for an individual to keep them in home and community-based services. Depending on the waiver, depends on what it pays for. Might be minor home modifications. That might be various therapies. It might be residential living situations. It just depends on the waiver. But the main thing is get on the list if you're not, and reach out. We'll certainly help you with that. But thank you. Thank you from myself, bottom of my heart, and CPG. We love what you guys are doing, and certainly making a difference. It takes a lot. It takes a lot of families to speak up, to say these things. The frustrations that we've had, or the kind of roadblocks that we've run into in our own families, helps for positive change in the future. There's one of those special needs resource fairs that I was mentioning before. So Boyd's office is here in the Katy area. Serving Texas. We've got all of his contact information, and everybody's going to get a copy of today's slides. So one thing that I mentioned this a lot. I'm sorry if you guys think I'm a broken record, but it's not about looking back or beating yourself up about what you haven't done. Do you have an outdated will or no will? Do you have no special needs trust? Do you need to have conversations about guardianship or alternatives to guardianship? So what I would say is don't beat yourself up about what you haven't done, or if you need to dust off what you've already done and get an extra set of eyes to look at it, and what updates need to happen. Make it a point to make it happen, to have an initial meeting with Boyd. Boyd can take a look at what you already have in place and make recommendations. I don't do what Boyd does. Boyd doesn't do what I do, but I do recommend, when it comes to your legal documents, that you have them reviewed by a trained set of eyes every 3 to 5 years. Laws change, people die, things change. Who you thought might be a successor guardian, or who you thought might be the best trustee, might not be that person anymore, because things have changed in their life. They're not willing. There's a broken relationship. They're not able. They're not here anymore, that kind of thing. So just dust your documents off. And what I encourage people to do is don't wait till the crisis happens. Everybody has known somebody that had a crisis, the heart attack, the stroke, the aneurysm, something that was an accident. I was telling Boyd that we had a family that the dad died in a Black Hawk accident, wasn't planned. but don't wait for the crisis. Have these intentional conversations now, because then what you want is going to be what is set up, as opposed to crisis is happening and the situation is the boss, right? So those are things that I would encourage for that. We always talk about the things to keep on your special needs planning radar. We have webinars on every single one of these topics. This little flower that you see on the screen, some people are listening by podcast, but we have a consolidated planning group YouTube channel. All of our past webinars live on that consolidated planning group YouTube channel. You can subscribe to it for free. There's no cost or anything like that. But so things that you should be thinking about. What is my special needs care plan, a comprehensive plan? What's next? What's next after high school? So many times we're just drinking from the fire hose and we're just operating on a today basis or tomorrow basis or one crisis to the next crisis. But having that plan is going to be more effective going forward. Future care cost estimates. How much money do I need to fund a special needs trust, small, medium, and large? What we believe in is we want to help you plan for the worst and we're going to hope for the best, right? Because a lot of families, when they have a young person, say they're 16, 17, 18, 20, 21, their brains aren't even fully formed until they're 26. So what you see at 18 is not what you see at Boyd's daughter's age 32, right? Lots of changes happen, but we want to help you plan for the worst, hope for the best. And then when the best happens, then that just means that maybe you can retire earlier. Maybe you can do some more traveling that you wanted to do, things like that. Texas waivers, the interest list, those webinars. If we talked about the Texas waivers, Medicaid waivers today, and it's the first time you've ever heard about that, go to the Consolidated Planning Group YouTube channel and search for the Medicaid waiver webinar and listen to that one. We do deep dives on SSI, SSDI, understanding the differences and knowing when to apply. We help people open ABLE accounts. We talked a lot about those beneficiary designations today. Special needs trust, how to fund them and when. There is no right or wrong answer. I am in agreement with Boyd about funding it after death, but there are other people that fund it while they're alive because there's plenty there. That's what they want to do. Or a grandparent funded a special needs trust when they passed away. And there are, other reasons around that. We want to encourage you to start touring residential living communities, post-high school options, transition programs. Some of these waiting lists are long. So again, we don't want you to wait till the crisis happens and you need something, but there's nowhere to go, right? These are really, really important. Boyd talked about guardianship, alternatives to guardianship. We've done webinars with Boyd and many others over the years about guardianship in Texas, alternatives to guardianship, how it all works. And you can start that process as early as 6 months. I mean, it's not official till after they turn 18, but you can get that ball rolling with somebody like Boyd early. And then we do post-high school options, educational options for individuals with disabilities, including kids who have intellectual disabilities. There are a lot of options out there, so we want to mention that to you. So we've got a couple of things. We bought the book, One Family, One Idea, One Big Change. It's very insightful and helpful. Thank you for putting that out. Oh, I want to maybe Carrie, can you put a link to that book? The book is great. Carrie's got a book out about this One Family, One Idea, One Big Change. And it's a great book. So you guys will want to check that out. I think it's on Amazon, right, Boyd?
Yeah.
Okay, she's going to put that out there. And then we have somebody in the chat box that says, what if a parent can't afford 3 to 5 or more to set up a special needs trust? So that does come up often. And what I tell people on that is that no matter where you are, we serve people all across the United States. So you can go on Google in your Google search and you can say legal aid, and you can put in your county, disability rights. Texas disability rights are in every state, but if you put legal aid and you put your city, or legal aid and you put your county, so if you're a family that has difficulty in paying that, there may be a sliding scale or lower prices in situations like that. So do check that out. And then, okay, so we did get the book link. Thank you, Carrie, for that. We have our Meet the Team slide. We finally updated it with all our team members. We're busy at CPG and we've got an awesome team. So we always like people to have some faces with the names of who you might be talking to if you engage the services of CPG. Okay. So I want to just mention, I've mentioned this a few times. We launched this in July. We have a new SSI, SSDI advocacy application and support service that we're offering. It's a paid for service. Jessica Alvarez runs our team on this. We're going to provide clear education on each step, guidance on where and how to obtain what records you need to obtain. We're going to organize all those documents for you for proper submission through the SSA portal. We're going to navigate the application. We're going to complete the application and any subsequent forms that you would submit through that portal. We're going to help with understanding letters. Sometimes the Social Security Administration sends letters. Sometimes they're long and very wordy. And after the end of a long day, it feels overwhelming when you read them. I for myself feel that way most of the time when I get letters from them. Um, but so we're going to help avoid those mistakes. And so if you're a person that you've been wanting help on this, you don't know where to start, reach out. We have free consultations and we'll talk to you more about the services, the doors that you can walk through with CPG and this specific service for somebody that is needing this for their child. So most of the time, people are not applying for SSI prior to the child turning 18 because it's based off of the parents' income and assets prior to the child turning 18, even though the child is disabled, but it's based off of the parents' income and assets. So if the parents have more than one car, if they have more than $2,000 in their name, and if they make too much income, it's not going to qualify. So a lot of people don't qualify for SSI prior to that time. It's after age 18. So what if your kid's 19 or 21 and you've never applied? What if you're hearing this for the first time? It's fine. But we do want to show the Social Security Administration if your child's disability started prior to age 22, we do want to be able to provide proof of that because there are additional benefits that your child will be eligible for if their disability started prior to age 22. Now, what I want to say is that if your child is already 22 and you're thinking, oh, snap, I didn't know this. Now I've missed the boat. You have not missed the boat. You just have to prove that the disability started prior to age 22. So don't panic. I just want you to know not to panic, but we can help with that. This link here is going to be for our upcoming webinars. You can register for any of our upcoming webinars that'll have the title and the description of what we are going to be talking about. For those that are listening today on the podcast, everybody that was here for the webinar is going to get a copy of the slides and a link to the recording. For those that are listening on the podcast, you can email us cpgcares.net and we will be happy to send you a copy of today's slides. This QR code that is on your screen, if you take your camera over that, it's going to take you to our calendar where you can schedule your free personalized consultation. That consultation is 45 minutes. It's designed to learn a little bit more about your family, what brings you to the meeting. We're going to ask a little bit about what planning that you've done so far, and we're going to share the doors that you can walk through at CPG and together make a determination if it makes sense for us to continue talking going forward. We're happy to help. If we're not a good fit for a family that we're talking to, then we're always happy to refer them to somebody that might be a great fit. So having said that, it is always a pleasure to partner with you, Boyd, and the Handley Law Office. Thank you for the information that you provided. Let me just check that chat box to see if we have any other questions. Okay, so we talked about creating a trust that protects money left to my child. So we did talk about that. And then the other person said that their main concern is guardianship and any material that we can send on that would be appreciated. So what I would say for that question, Boyd's contact information is also in the slides. It'll be in the email that we send out. Reach out to Boyd directly. He's got a nice packet of information to share about the guardianship process, and he can certainly have a consultation with you as well. So thank
Also,
you. Yes.
Allison, one comment on the lady with the person with the question on the cost of the trust. There's something called the Texas Pool Trust. They may want to look into because it has two third-party trusts and two first-party trusts. So that may be something that they can look into also.
It might be a lot cheaper. That's a good point. I don't know what the minimums are for those, but I think that that is definitely worth looking through. It's the Master Pool Trust through the Arc of Texas. That's a great point. So thanks so much. It was somebody said, I'm sorry, what was that again? It's the Master Pool Trust through the Arc of Texas is that. And then the other one is Googling legal aid near me and putting in your county or your city there. Well, thanks everyone for being here today. It's certainly been our pleasure, and we will look forward to partnering with you guys again soon. Take care.
Take care. Bye bye.
Bye now.